Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
Question number 132. Citibank expands its operations in India. They implement an automated fraud detection system to prevent fake orders and identity theft. A customer places a large order online for delivery of goods to him. Automated procedure of the bank the notice the transaction unusual for the customer. Had never placed such a big order in recent times. The bank blocks the transaction. The customer suffers a business loss. As a result, by missing a contract with the deep business implications, the customer sues the bank beside the status of the complainant's application. So now here in this case, what would be the situation? Legitimate interest. Here, definitely the bank has legitimate interest in ensuring the customer's money. In ensuring that the customer does not fall into evil hands. Therefore, they have a legitimate interest, but there is no protection as per the article. Therefore, the bank would become liable as per the readings of the article. Right? Bank is not protected irrespective of the protection offered to the customer. Right? Bank is protected because it offered protection. No. This may not save the bank because they have not complied with the mandatory requirement of law. Bank should install better system of fraud detection. That is tangential. Okay? Now I come to question number 133. A journalist in Austria seeks customer transaction records from green basket to expose. Now the place is significant. That is how Austria. That means European Union seeks customer transaction records from green basket. The customer transaction records are being sought, and you know that legitimate interest transaction, legitimate interest in the transactions would protect the bank from sharing the data, overriding the privacy concerns of individuals. Green Basket delivers the data in contracts with customers. Green Basket had already notified their customers that they would use the data for their protection. Journalist unearths that a customer carries out multiple transactions of the same item from the same location but with different cards. Green Basket gets the cards blocked. It turns out the transactions are valid. The blocked customer claims to have suffered losses as a result and moves the court for recompense. Decided the So this is very clear, right? Can you tell me why the bank will not be held liable? Can anyone tell me? Why the bank will not be held liable? Yes, Tanishka? In question number 133, can you tell me why the bank will not be held liable?
Sir, because the customer agreed in contract to use the data for protective purposes. I
Yes,
think
because of
that's
the
why.
legitimate, because um, because they have this legitimate interest exception. Even if the customer did not agree, then to what they are doing is to see whether there are any transactions which are suspicious. They have a legitimate interest. They are not carrying out a fraud. They are, they are acting to prevent a fraud. Therefore, even if the contract with the customer did not actually permit the sharing of data like this, sharing of data, some third party, like an Austrian journalist who intends to carry out some research, then too they are protected as per the doctrine of legitimate interest. Okay? Right? Chalo. Then we come to Green Basket operates in Sweden and processes customer addresses for delivery grocery bags. So here also company also uses addresses to send targeted advertising for eco-friendly products. Customer sees a large number of spam emails in his inbox. He sues the company for such soliciting beside his application. So in this case, what should be the situation? Why why the company should not be held liable to the customer? What is the reason? Can you tell me? What is the reason why the company should not be held liable to the customer?
Sir, because it's for promotional purposes.
So promotional purpose might be called to be a legitimate purpose, according to you, right?
Yes, sir.
All right. What can be the other reason? What would be the for contractual necessity? How will you deliver the grocery bag? If you don't use, suppose I am ordering something on Zomato. If Zomato does not share my address details with the company which organizes the errands boy, services of the errands boy, that is the that is the boy who delivers those packages, the person who delivers those packages. If that kind of thing is not permitted, sharing of that kind of my personal details is not permitted with the company which is organizing the transportation, the last mile or whichever mile, the actual transport of the food packets. Zomato is a food platform, food delivery platform. They don't produce anything. They just aggregate the demand from various customers, and then the concerned restaurant supplies the goods, the food items, edible items, to the to the to the customers, right? So it is a demand aggregator. Now, if Zomato does not share the customer details with the person, with the delivery boy, and the company of the delivery boy, then how the packages will be delivered? So this becomes contractual necessity, right? Yes or no? Now you understand the practical significance of this? Yes or no? All right, come to 135. Green Basket decides to open a branch in New Delhi and processes customer addresses for delivering grocery bags. However, the company uses these addresses to send targeted advertising for eco-friendly products. Now you will notice what has happened here is Green Bars decides to open a branch in New Delhi. This is interesting. Now we come to India, and now Green Basket has come to India. Earlier they were operating in European countries, sometimes in Austria and sometimes in Sweden. Now we have come to India. Now what they are doing now, they share the grocery addresses, the address. Then what should happen? The company should be held liable or should not be allowed. If they don't take the consent of the customer, can they share his data with the grocery boy, with the grocery delivery boy? Can they do that? Yes or no? What is the difference when the company operates in Sweden and the company operates in New Delhi? What changes? What are the changes that are taking place?
So it against the Indian consumer privacy and data privacy law. You cannot use
Yes. So they have not taken the consent of the customer. Here, the legitimate interest is not there because the legitimate interest exception is not recognized under Indian law, and contractual necessity is also not recognized under Indian law, right? So in this case, neither of the exceptions are available to defend the company, and therefore the liability can be fastened upon the company for having acted without consent. Okay, all right. Please come to yes, 22.
this passage talks about the India Enforcement Directorate and Central Bureau of Investigation are often as a fourth branch institution,
Mhm.
but this classification is factually and due to their structural and functional dependency on the executive. And the scholars like Bruce Ackerman and Mark define these independent watchdog monitoring the executive, legislature, and judiciary. Unlike the constitutional fourth bench institution, like election commission, as the ED and CBI are statutory body making the vulnerable to executive influence, and the CBI director is appointed by the community, but officer below the selected by the executive control panel, and ED directly chosen by the bureaucratic panel where the executive hold veto power, and the ED operates under the finance minister, limiting the autonomy despite its sweeping the power under the PMLA, and the judicial ruling, the Vinit example, Vinit Union of India 1998 called for the independence was but lack of the enforced boundaries. And the South Africa Constitutional Court maintains the institutional independence for investigate agencies, and the multi-member leadership to prevent the power centralizations and independent appointment panel with diverse political representation, and minimal executive interference in the daily operations, and judicial based on the non-partisanship and transparency. India does not need constitutional amendment, but it must structurally reconfigure ED and CBI to reflect the democratic value, and until then calling them food transmission. Uh,
This article basically highlights the one question, which is are ED and CBI truly independent, like fourth branch institutions, or not? So, in this article, it says that some people suggest that India's ED and CBI act like a fourth branch of government, which is basically independent from the executive, legislative, and judicial branches. But this article argues that that's not true in practice, and these agencies still depend heavily on the central government for their powers, appointments, and daily functioning. And unlike purely independent bodies like the Election Commission or CAG, ED and the CBI were created by the ordinary laws, making them easier for the ruling party to control. And for example, the CBI director's appointment seems balanced on paper, but most officers are selected by the executive control panels, and the ED is directly under the finance ministry, and even the panel that selects its director, it is largely filled with the bureaucrats loyal to the government, and even their powers are restricted. And the CBI needs government permission to investigate senior officials, and the ED has wide powers under the money laundering law, but it is still administratively controlled by the government. And courts have acknowledged these problems, but they haven't fixed them strongly enough. And uh, in comparison with countries like South Africa, uh, they have granted independence for similar agencies in their constitution. And this article ends by saying that India needs reimagined investigative agencies, one with independent leadership, transparent appointments, less government control, and full accountability to all of Parliament. Until then, calling ED or CBI truly independent is more wishful thinking than fact. That's all for my side.
Yes.
So this article is basically asking whether the Enforcement Directorate and the CBI are considered to be fourth branch institutions or not. Now, is critical of these two bodies and has a tone that says that these are not completely independent and shouldn't be called constitutional bodies. Now, fourth branch institutions are uh, constitutional bodies that have independence from the three wings of the government, which are the executive, legislature, and the judiciary. Now, these bodies should operate in independence from these three, but the problem with ED and CBI is that unlike the other constitutional bodies like the Election Commission of India or the Comptroller and Auditor General, the ED and CBI lack the constitutional backing these previous two organizations have, which makes them vulnerable to the executive influence. and are affected by legislative changes. Now, the key issues that the article mentions with these organizations is that uh, these organizations work through are subject to the legislative in many ways, since in the for example, the parliament can simply pass an amendment to restructure the CBI or the enforcement directorate, which allows the legislative to have a lot of control over how these organizations can function, and combine that with the control that the executive has in deciding who the heads of these organizations will be, is a raises a question on the autonomy of these institutions, since institutions are meant to keep the executive and investigate the executive and legislative branch of the government. And in case there's a conflict of interest, which there would obviously be, then if we look at the influence these two branches of the government have on these two organizations, then how can we trust that these organizations will work in independence and not end up being controlled by the legislative or the executive? Now, the courts have raised this issue many times in cases like the Common Cause versus Union of India in 2018 and the Jai Thakur case, but they have not implemented any uh, policy changes or then any something like a or pass an order for enforcement. Thus, there have been effectively no changes in how the organizations are functioning. So the key issue here is that there's no constitutional enforcement in these organizations, and these agencies possess immense power and are subject to political misuse a lot, which violates the equality before law that must be followed, which violates the democratic design of the entire organization. So that's really the gist of the article. It also provides an example in South Africa, where the constitution explicitly mandates the independence for investigative bodies and states that India lacks this protection that the South African constitution provides in case of the education enforcement directorate and the CBI.
So you have a situation where a question arises as to who will look after the integrity of government finances, right? You have the institution of Comptroller Auditor General of India to look after that. He will audit the government's finances and will report to the parliament on whether or not the government's finances have been spent in the manner they were sanctioned, and the integrity of the process has been maintained. Likewise, the question arises as to who will maintain the fairness of the electoral process. That in a democracy, election is one of the most important events, national events. One of the most important national events is the peaceful handover of power from government to government, from one term to another 5-year term. And this is intermediated by free and fair elections. And which institution will provide all that? Obviously, the Election Commission of India will provide all that. Likewise, the Right to Information Act implements the fundamental right to information, the right to free speech and expression as enshrined in Article 19(1)(a) of the Constitution. Which institution is going to implement that? The Central Information Commission CIC has to implement that. So you require a number of institutions in order to ensure the accountability, transparency, and the democratic temper of our constitution. Constitutionalism depends on these institutions. So an argument is sought to be raised by the author in this case that look, these institutions and the institutions he identifies are the CPI and the Enforcement Directorate. These two institutions he identifies, and he tries to understand whether we can call that these institutions are independent watchdogs. That is, these institutions, although they are outside, they are supposed to be outside the legislative, executive, and judiciary, that hierarchy or that those separate hierarchies, whether those institutions are independent enough in order to serve the function of a watchdog. So that is the answer the author, that is the question the author poses to himself. And he comes with an answer that these institutions are not capable enough by their organizational structure as well as their functioning operational operations. They are not independent enough to be called as the fourth branch institutions, which can remain outside the influence of legislature, executive, and the judiciary, and ensure that constitutional norms, constitutionalism is upheld, and they may ensure that the purity of elections is maintained, the purity of government finances is maintained, the canker of corruption does not vitiate any part of the government's functioning by strict implementation of the right to information. Corruption is monitored in the government bodies through the Central Vigilance Commission, and the author seeks to examine whether the high norms, whether the high expectations of these institutions can be said to be met by their operational as well as structural organization. And the author comes to a conclusion that by no stretch of imagination, these institutions are independent enough, these institutions are strong enough to resist the executive or legislative interference in their working, and therefore, first and foremost is that even to start an investigation, they require an approval or nod from the executive. And almost at every step in their operations, also they are tethered to the government dictates. They are not made immune from it. There are some jurisdictions where the author says this has already happened, and there was an attempt made by the executive to tether such institutions to its domain and organizational hierarchy. But that attempt was robustly repulsed by the South African Supreme Court. So this is basically the short framework within which the article goes. The article basically analyzes the functioning of these and operational functioning as well as the structural organization of these organizations, and comes to a conclusion that much is to be desired by way of reforms. And even if their appointment apparently seems to be in such a way as to make them immune from political or executive influence, but the actual operations or the organization down the hierarchy is not of such a nature. And even in operations, even to commence an investigation, they require permission from the government, from the concerned ministry of the government to which they are tied. This is not the case with the Election Commission of India. They determine their own. They determine the schedule of elections. They may disagree with the government in the schedule of elections. If you remember, in 2022, 2002, the Election Commission of India postponed the elections in Gujarat because they said that because of Godra riots, the atmosphere is not conducive for elections, and they postponed the elections on those grounds. The state government of Gujarat took the Election Commission to the Supreme Court, They argued the matter there that this kind of thing cannot be done by the by the election commission. Nevertheless, the Supreme Court sided with the election commission, stating that they have every right to postpone the elections if they feel that free and fair elections are not possible in the given circumstances. So that kind of operational independence the author is talking about. The author says that my concern is that this kind of operational autonomy is not existing in those institutions, and if those if this such operational autonomy is not there in these institutions, then they will not be able to fulfill the purpose of. They will not be able to uphold the laudable objectives that they have of ensuring accountability, transparency, and democratic governance. That would not be possible. That would all become skewed, right? So this is what the article talks about. And now let me quickly rush through the questions, because today also we have been rather slow paced, because it is already 4 o'clock and we have not finished the number of articles that we had set out for. Now, the first question is 136. So 136, the responses seem to be incorrect. So I'll take 136. During a national election, the Electoral Integrity Commission investigates allegations that electoral voting machines were tampered with to favor a specific political faction. This ensures political free and fair elections. So this is a fourth branch task which has been assigned to it. Now, political entities attempt to discredit the commission using legal obstructions and media manipulation, but the EIC resists suppression. All right, the Electoral Integrity Commission is able to withstand the pressure which is applied on it, and is able to very straightforwardly deal with the situation. For the above situation to come about, what institutional changes will be required? So this is a question on what should be the recommendations. Now, constitutional insulation, jurisdictional authority, and investigative independence to shield the EIC from political retaliation. Well, this will be required. Our constitution also has provisions which insulates the Election Commission of India from unnecessary, unwarranted political or executive interference. They don't permit. There is a separate chapter on this. I presume Article 323, or which one is there? For starting from that, there is a complete chapter on the Election Commission of India. So constitutional insulation is surely required. Jurisdictional authority is surely required. Investigative independence is very much required. If you are out to investigate whether some communal appeals were made, and if you take the dictate of the government that look, no communal appeals were made, just write in your report and matter comes to an end. So that kind of thing can very severely compromise the democratic framework of India. So all these things are required. Then second is executive oversight. Now, executive oversight is not required here, because executive oversight means no characteristic of a fourth branch institution. The judiciary, executive, legislature, they are kept free from all these interference. Strengthening public disclosures and whistleblower protections. Now, if you strengthen the whistleblower protections, this surely is going to help, because whistleblower protections basically mean that if something wrong is happening and you come to know about it, then if you complain about it, then your identity will be kept secret, right? Those are whistleblower provisions. So whistleblower provisions will definitely strengthen the democratic framework, and make it easy for the commission, Electoral Integrity Commission, to carry out its tasks. Media controlled election integrity narratives. Never. Media narratives may be highly supportive of certain political alignments, so that will not be proper. Statutory insulation, not sufficient. Statutes can be manipulated. Constitution is required where you require higher majorities, special majorities, ratification by half of the states. And when you have different governments in the state, it really becomes very difficult. Different governments in the state and a different government in the center. So look how difficult it became for the Aam Aadmi Party to rule Delhi during its last tenure, because there was a different dispensation in the center and in the state it was Aam Aadmi Party. So it can really become difficult. So constitutional insulation is required. I hope that clears it up. Yes or no?
Yes, sir.
Very good. Promptly you should speak when you are asked to. Then it gives a very encouraging sense of encouraging involvement in the class. Which of the following legal arguments highlights executive influence over the appointment process of investigative agencies in India? So, which one shows that there is an appointment of CBI director by a committee comprising of Prime Minister, Leader of Opposition, Chief Executive? Now, these are independent. Prime Minister, Leader of Opposition is anti-Prime Minister. Chief Justice is neither anti nor pro. The Leader of Opposition or Prime Minister of India, his job is entirely different to uphold the Constitution of India. So this will ensure the independence. Presence of bureaucratic and judicial members in appointment panels. The moment bureaucratic elements are there, then the hierarchy is there. So they will be subsumed in the system. They will not be independent. Then appointment of ED directors through parliamentary voting. Now, if parliamentary voting is there, parliamentary voting is on party lines, right? So, ED directors, if they are appointed through parliamentary votings, then the executive influence is all pervasive, right? Then the executive appoints directors with consultation with other. Now, these consultations are not what you call as the consultations are consultations. They may take the consultation, they may reject the consultation. So, executive influence is paramount. Surely. 100%. What key distinction sets South Africa's investigative institutions apart from India's ED and CBI? This everybody has referred to. South Africa's constitution explicitly mandates institutional independence for investigative units. That is a very nice thing they have done. South African investigative agencies function solely under parliamentary control. No, they are independent. Right? South African executive enjoys complete discretion or autonomy. No, that is not what they are saying. South Africa does not recognize labor. No, that's one thing. So this is very clear. Come to passage 23.
So this article is about gig workers and the laws associated with gig working. So gig workers have become gig working has become a norm these days, with many companies offering such works. So with this rise in gig jobs, the Rajasthan and Karnataka government have passed a gig worker law, to provide some benefits to these workers. However, the issue with these laws is that they do not recognize gig workers as employees and gig companies as employers. These laws call platforms as aggregators and workers as independent contractors, effectively sidelining the employer-employee relationship that they have and making them independent, thus taking away responsibility that the employer or the aggregator in this case should have to the gig worker. Because of this, there are many issues such as weak worker protections, due to which there are no minimum wages, there's no definite working hours. Companies do not have to respect the occupational safety hazards that this work might have, nor are there any trade union rights. The other problems that this causes is that for example, in Karnataka's model, there's this welfare board for the gig workers, similar to those in the construction sector, where companies do not have to pay much of attention to the welfare boards, and is all handled by the government. However, this model ignores the very strong control that the platforms have over the gig worker schedules, may it be pay or even work hours, which define the employee-employee relationship, but it is not recognized here. Now, in contrast to the UK's gig workers law, so the UK courts have recognized that gig workers, such as Uber drivers are employees and not independent contractors, and such the platforms that employ them must follow the employer laws, and in turn, they should do what should be done by such the employer. So this article caused the laws that were implemented by the Rajasthan Karnataka government as simply there's a lack of recognition of the employment. So the workers end up remaining excluded from the labor rights that others enjoy. Now
Yes.
this harms the dignity and the dignity of the workers that get employed by these companies. And in turn, could pose a threat, since if such a trend is followed by other states as well, this could harm the sector that is created, the economic sector that is created by these gig workers, which is not beneficial to the country and could harm them
This
as
passage
also.
this passage talks about the Indian gig worker where they they have a lack of basic right, and in recent law in Rajasthan and Karnataka failed to address the absence of employer-employee recognition, and gig companies also avoid the employer status and the label worker as an independent contractor to evade their labor law like minimum wages and provident fund, and gig worker lack benefit security and bargaining power despite the following platform imposed rule. Under the Code of Social Security 2020, they recognize the gig worker but only offer a scheme based benefit, not institutional entitlement like gratuity at the
Yes.
maternity leave, and treat gig worker like unorganized labor, avoiding the employer obligations. In
Yes.
addition, the bill mentions the weekly payment but does not set an income floor where the workers' representation is assigned to the government nominees and excluding the union. And the bill sidesteps the Industrial Dispute Act and weakening the collective labor rights, and offer only extended benefit, leaving the other right to welfare board creations and access to scheme require the workers' contribution despite the low earning. And under the Supreme Court, UK Supreme Court ruler Uber driver are employed entitled to minimum wages, paid leave, and protection. But in India, the law ignored this precedent, failing to address the worker right. They should take the lesson from UK, and India must formally recognize the gig worker as employed to ensure the fair pay dispute resolution and occupational safety. And welfare board alone cannot guarantee right. Platform must be also held accountable, and the future ready labor law must name the employer to the prevention exploitation.
So we will start from here only, and then come to the logical reasoning part, which is still left. Today we are supposed to do more, but unfortunately, we have cut short the session. Right. So tomorrow we will meet and finish it off. Okay.
Dear students, GPS CLAT Academy at Gyanoday, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.